Good morning. I am Marco Novara, a PhD student at the University of Milan. In this presentation, I will be discussing the research issue and findings from my paper titled The Trigger Point of Crisis Relevance, Italy's Transposition of Directive 2019-1023, between a rigid and a flexible model, which forms a chapter in the book Insolvency Law in Times of Crisis, published by INSOL Europe. The chapter starts with the well-known fact that the directive provides that the concepts of insolvency and likelihood of insolvency are defined by national law. This leads to the so-called issue of the triggering point, that is, the problem of identifying the thresholds of the worsening of the company's economic financial conditions relevant for the activation of the mechanisms provided for by insolvency law. This is a problem of great relevance because it depends on the achievement of the goal set by the European legislator to anticipate the perception of crisis and insolvency. The problem is also highly topical because it shows some important points of contact with the proposal of the European Commission for a directive harmonizing certain aspects of insolvency law. The chapter examines the solution offered in this respect by the Italian law, taking as a benchmark two abstract legislative approaches to the subject, which I refer to as a rigid approach and a flexible approach. These two approaches are adopted in particular by German and English law. On the first side, the rigid approach triggers the duty to adopt a specific solution to the crisis upon the occurrence of certain conditions identified in advance. Section 15A of the INSO provides that when a company becomes illiquid or over in debt, the directors are required, without delay, to file a request for the opening of proceedings. On the other side, the flexible approach entrusts the assessment of the debtor, in the case of a corporate debtor, typically the directors, to identify the triggering point. In the English system, especially with regard to the wrongful trading rule, the law relies on the director's forward-looking assessment to determine the triggering point of crisis relevance. Indeed, they should assess whether there is or not a reasonable prospect that the company would avoid going into insolvent liquidation. As far as Italy is concerned, it should be noted that in the first version of the recently approved Insolvency Code, the legislator adopted a rigid approach, as it defined the crisis on the basis of a system of crisis indices. However, the latest version of the code, the one that actually entered into force, no longer provides for crisis indices, and the Italian system has reverted to adopting a flexible definition of crisis. Taking my inspiration from this strange legislative development, in the chapter I ask why the legislator changed its defining approach and thus highlight the advantages and disadvantages of the two models. In conclusion, I attempt to show how neither the flexible nor the rigid model offers a satisfactory answer to the triggering point problem. Consequently, I propose an interpretative solution based on an hypothetical mixed model. In particular, at the outcome of my research, I suggest that the preferable model is one that contemplates the presence of crisis indices, the detection of which, however, need not lead necessarily to the conclusion that the company is in crisis. More specifically, exceeding the thresholds of the indices should give rise to a rebuttable presumption of the existence of the crisis. When the values represented by the indices are exceeded, the directors should examine the economic and financial condition of the company, but may conclude that there is no likelihood of insolvency and rebut the presumption. In this way, two useful results are achieved. The triggering point is prevented from being identified by an automatic mechanism, and therefore a source of possible false signals, and at the same time, the judgment of the existence of the crisis is formulated through a controllable logical process, with the consequence that the formulation of the assessment could be checked in court.